Hey guys, I'm going to talk a little bit about prior testimony, particularly as it relates to the Murdaugh case. And, sometimes it comes up in other cases, so it can be good to understand it. Let's get these slides rocking here and we'll check it out. All right. So, of course, Murdaugh took the stand in his first case and did his best to persuade the jury that he was not guilty or even innocent. It didn't end up working, but he's now seeking a new trial for some unrelated reasons currently, which is the situation with the jury. That's would not be the principal grounds for appeal that he was going to be following until he made the current motion. Anyway, he's seeking a new trial either because of this jury situation, or if that doesn't work, then he'll go back to his normal appeal, and you'll have it. It does happen sometimes that a defendant will take the stand, although they usually don't, but sometimes they do. Maybe they try and catch the DA off guard or something, and they realize it didn't work. And then in the second trial, maybe they think, well, I'm just not going to say anything this time. What happens then? Let's take a look at it. So what is hearsay? This is North Carolina, but you'll see in a second, South Carolina. It's the same in most places are. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. So generally speaking, if you're in a trial, something you said in a trial before that or some hearing before that, that's going to be hearsay under the classic rule, right? Because you're supposed to be testifying live at the trial or hearing that you want to put this evidence in. That makes it not hearsay, unless something you're saying is hearsay, repeating something somebody said or whatever. But let's talk about the general rule, which is testimony is supposed to be live at the current hearing. The court wants witnesses to get up on the stand in front of the jury or the fact finder, tell what they've got to tell the evidence, not recorded statements from past things and stuff like that. There are exceptions, just like there are general exceptions to hearsay, of course. There are exceptions to the witness being there. And one situation would be the declarant is not available. And the classic good reason to not be available is being dead. That's an acceptable excuse. It's not the only one. But it can't just be that the person died and then you want to play something that they said or whatever from a prior hearing or whatever. The defense had to have, we're assuming it's a defense in this case, had to have the motive and ability to, I wrote testify here, sorry, to cross-examine on relevant issues. So if the witness is testifying, the defense or the party that they want to put this evidence against, they have to have the ability to cross-examine. That's true in civil cases and criminal cases. Otherwise, you can't really confront the witness. Also, a big exception is admission of a party opponent, because you can't be complaining about not being able to cross-examine yourself. So there's really not a confrontation issue. That's a big one, admission of party opponent. So in a civil case, that could be either side, and it can in a criminal case too. But keep in mind, the party opponent in a criminal case, as far as the state's concerned, is the criminal defendant. So can Murdaugh's testimony be used against him? Well, I've heard some people say, well, yeah, they can impeach him with it. But if he doesn't testify, you can't impeach him, right? But, when you watch cases, you're going to see things come in, the defendant sitting over there not testifying, but you might hear a prison snitch say, well, he told me in the cell this, friends, family, enemies, strangers, the police. Oh yeah, he said this when we were in the police car after I read Miranda, interrogation video down at the station. You see all these things being shown that the defendant is saying, even though he's not testifying, but it does seem to capture the popular imagination that if this person testified at some other trial, well, you can't use that. I'm not sure why people think that. Why not be able to use prior trial testimony? That's actually under oath, which these other things generally aren't. So it ought to be, in theory, the most reliable. So why couldn't you use that, right? So let's look at the South Carolina rule here, 801. And of course, they define hearsay there. You'll see it under C. It's what I already said, which is basically a statement outside of the current trial or hearing offered in evidence to prove the truth of the matter asserted. And you see down at the bottom there, D2, admission by party opponent, the party's own statement, et cetera, et cetera. So that's generally how these things come in against criminal defendants. It's an admission by a party opponent, a statement against their interest. Otherwise, it'd be hearsay. What the defendant told his friend or said down at the police station, that's not what he's saying at the current trial because he's not testifying. So it would be hearsay, except it's defined as not hearsay. And that applies to prior testimony as well. And here's a couple of examples. And I mentioned this in the stream the other day. The top left is Michelle Young, and there's Jason Young, who was her husband. He kind of surprised testified in his first murder trial, but the jury hung on that. The second trial, he decided not to testify. He had lied his butt off on the first trial. So the prosecution was able to play the tape of him lying to the jury in the first trial and then show how that was a bunch of lies. At the bottom right is Brad Cooper, who underwent a civil deposition, and that was used against him in his case, which he was convicted, but he ended up pleading later after appeal stuff. So those are some local examples here where somebody's prior testimony is used against them when they're a criminal defendant. But South Carolina is special. And this is one of those things where I always say it depends. A lawyer kind of has to say that because every state can have their own definitions of these rules of evidence as long as they're not inconsistent with the Constitution. And here in South Carolina, or there in South Carolina, I'm in North Carolina, they have a very special statute that you don't see other places. And it says this: the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. So they accept the general rule there that if you're actually testifying in a criminal case, you can't use it against the person in some other criminal case, right? That's weird, right? It doesn't say any other civil case. It just says criminal case. So those words are going to be pretty important in the Murdaugh situation. Any other criminal case, whether it's an other case or not, because if he gets a new trial, it'll certainly be an other trial, but I don't know that it means it's another case. Now, in South Carolina, the law enforcement side says, why do we have this statute other places don't have? Because the general rule is if somebody gets up on the stand and talks, that ought to be able to come in against them, right? Like it does in every other state, because we can use their interviews, their statements to their friends and things. Why in the world would we not want to be able to use their statements made under oath in a case? And it doesn't make any sense. So they said, you can see this was from 2012, if confessions given outside the presence of counsel are admissible in court, then any sworn testimony in the courtroom, which has the benefit of being counsel, recorded, and judicially informed, should be admissible too. And that is the general rule everywhere. It's very bizarre. As they say, the statute provides a safe harbor for defendants who choose to only acknowledge their crimes in open court. It's not constitutionally required, hinders the state unnecessarily. It is really strange. Not the general rule. They cite an example where it was problematic, but after we go over that, we'll go into why this may come in the other direction for Murdaugh. So they cite a case called State versus Rivera, and this guy met two women at a mall in 2006. And the first woman he set up a date with pretty quickly, went to her house. They had sex. Then he strangled her to death, cleaned up the body, and left. On the 14th, he goes out with the next woman that he met at the mall. They have dinner. She doesn't want to have sex with him, but he nevertheless pushes that anyway, strangles her to death in front of her 2-year-old daughter. He then hog ties her body, places the 2-year-old girl on top of her dead mother, and leaves. And he was caught. He gave a written confession. So pretty nasty, right? So in 2008, he goes on trial for the first woman's murder. And during that trial, he decides to give a detailed, what they call bone-chilling account of how he murdered both of these women. And then he was convicted naturally. Then he goes on to a death penalty trial for the second woman. And during the penalty phase of that, the state wants to introduce his testimony from his first trial to show what a nasty monster he is in the penalty phase of the second trial. And the trial judge there said, I'm not going to let you do it because this is an other criminal case. In the criminal case where he murdered the first woman, he said all these things under oath in open court, right? But now he's being tried for the other woman's case. That's another case. So it's not allowed, not going to allow it. Now that's weird because if he had given the police an interview in the first case and said all this stuff that could be used in both cases, it's only because it was testimony in the first case that they said, nah, we won't hold him against him. And that is special for South Carolina and not the general rule. And hopefully you can see why there's some logic gaps in that. Now, this issue has gone up to the South Carolina Supreme Court. So this case, I'm sure, will be important to these guys as they litigate it. This guy was convicted of murder, armed robbery, grand larceny, first-degree burglary. Another winner. He got the death penalty, but that was thrown out. So he was granted a resentencing trial. So let's look at what he did. He broke into Shannon Mellon's house, 1992, armed with a gun. He tapes her up and her ankles, leaves her under bed while he searches for things to steal. Then he goes back in and shoots her in the head. while he's packing up more of her stuff, she regains consciousness and sets up and says, "I can't see." So he shoots her in the head again. Then later on, he hears her breathing heavy, so he shoots her again in the head, 3 times in the head. Then he drags her body into the woods where she was discovered a week later. He was apprehended in North Carolina, so I'm glad they got him back. Well, here's what he's complaining about. That when they granted the retrial, okay, for the sentencing phase, the death penalty phase, they used some of his earlier testimony from the original trial. He says, "Hey, you shouldn't be doing that." And the South Carolina Supreme Court says this. Under Rule 801D2, which we looked at, an admission by a party opponent is not hearsay if the statement is offered against a party and is the party's own statement in an individual or representative capacity. So accordingly, his earlier testimony was not hearsay. Trial court did not err in admitting it. But then he says, "But wait a minute, what about the special statute that South Carolina has that protects criminals if they want to say something in one trial and not have it come back on them in some other trial, even though it doesn't protect what they say to police, strangers, friends, and all that?" So the criminal also argues the admission of this testimony violated South Carolina Code 19-1150. That's the special statute. The Supreme Court said, "We disagree." Because, and look, they put in italics, other criminal case. Okay. So that's why I said that word is going to be very important to Murdaugh if he does get a new trial. Here, the testimony was offered in a resentencing proceeding in the same criminal case. Furthermore, the testimony was merely cumulative and all that, but they call the resentencing phase, the retrial on sentencing, part of the same case. Okay. And I think that's a fair reading of the statute. So the trial judge did not err in admitting this evidence. So the general rule is you can use a defendant's prior testimony in a courtroom because it's an admission of a party opponent, just like you can use their statements to the police, to people on the street, to victims, whatever. South Carolina has this special statute that is beneficial to a criminal defendant, protecting their testimony from being able to be used against them in some other case in the future. You can't use it in any other criminal case. Now, resentencing trial was considered to be part of the same case. So I think it's likely that a mistrial, and they go back and try it again, a new trial, would be considered the same. It's a new trial, but it's part of the same case. It's for the same crime, right? So that would be, to me, the way the Supreme Court, South Carolina Supreme Court, would read that logically. But it's not exactly on point. So I'm going to say they could use his prior testimony against him. Of course, it's not certain because they don't have a case directly on it, and they have this weirdo statute. But since it is part of the same case, it wouldn't be part of another case. And then it would fall back to the general rule that most states have, that you can use a criminal defendant's prior testimony in another proceeding against them. So that is it. And talk to you guys later.